Scott McGirr is an associate lawyer at McGirr and Associates in Halifax, where he's been practicing immigration law since 2013. He appears regularly before the Immigration and Refugee Board and has successfully argued many cases before the federal court. Scott first became interested in this area of law through taking on refugee and humanitarian cases for the Halifax Refugee Center, which he joined as a volunteer in 2008. He later served as a member of the board of directors for this organization, and he's a graduate of the Schulich School of Law. So thank you very much, Scott. Come on up. Kel, is that good?
Great.
Thank you.
Well, first of all, I want to say that I'm stepping in for Lee. So to any of you who are coming expecting to hear Lee speak, which is usually a treat, prepare to be disappointed. While I lack Lee's oratorical flourish, I don't make up for it with decades of experience, but I have been working with Lee for the last 6+ years, and some of his experience and knowledge has trickled down. Thankfully for all of us, it's near the end of the day. The subject matter which I'll be speaking on is not nearly as substantive as everything that's come before us. I'll be speaking, as Julie said, on the implications of criminal inadmissibility for citizenship applications, as well as for family sponsorship. And both of these issues are quite straightforward. With respect to the implications for Canadian citizenship, just briefly, although this is very basic, and I'm certain everybody is quite familiar with it, but the basic qualifications for citizenship are: the applicant must be a permanent resident of Canada, must have been present for 1,095 days in the 5 years preceding the date of the application. If required, must have paid taxes in 3 out of the 5 years. If applicable, which is to say if they are between the ages of 18 and 54, they must demonstrate knowledge of French or English with satisfactory language test results. Must, again, between those ages, demonstrate adequate knowledge of Canada through the citizenship test, which is assessed after the application. Not be under a removal order, and not be inadmissible or prohibited on grounds of criminality or security. So for our purposes, it's the first two and the last two citizenship criteria that are most relevant. Looking at the last one, in terms of the implications of criminal inadmissibility, given that criminal inadmissibility would result in inadmissibility, if you are criminally inadmissible, you are not eligible to apply for Canadian citizenship, the end. But apart from criminal inadmissibility, there are also implications, prohibitions resulting from criminal convictions or charges that are a little more nuanced. With respect to inadmissibility, as a permanent resident, which you must be to apply for citizenship, you can only be found inadmissible for serious criminality, which is defined in the IRPA in section 36 sub 1, having been convicted in Canada of an offense with a maximum sentence of at least 10 years imprisonment or a sentence of more than 6 months imprisonment. Following trend, we know that conditional sentence orders, house arrest, do not count as terms of imprisonment. So it has to be a custodial sentence in a correctional institution. Convicted outside of Canada of an offense that, if committed in Canada, would be an indictable offense that would attract a sentence of at least 10 years. There's also inadmissibility stemming from committing an offense that does not require conviction or even a charge. And again, it's committing an offense outside of Canada that, if committed in Canada, would attract a sentence of at least 10 years. Now, the committing an offense provisions are very rarely implemented. I have never seen them implemented to revoke permanent resident status or to lead to inadmissibility of permanent residence. Where I have seen them are foreign nationals applying for permanent residence who inadvertently committed bigamy by marrying somebody before their divorce was granted. It's never been a charge, but when you apply for your permanent residence, you provide the information related to your first marriage, you provide your marriage certificate for your second marriage, and when you don't provide a divorce certificate for the first marriage, you are now inadmissible for criminality. And generally that would not attract serious criminality. And it's a pretty easy fix with a rehab application, generally speaking. When it gets to the point where you're ineligible to apply for citizenship by virtue of your serious criminality, you have other problems to worry about other than your eligibility to apply for Canadian citizenship. You're likely looking at best case scenario, you're looking at if you qualify an Immigration Appeal Division hearing, which is going to take several years to be scheduled. And given the circumstances, your focus ought to be there and not on whether or not you qualify for Canadian citizenship, because while those charges are pending, or while your removal order is pending, you're not eligible for a grant of citizenship. It's the implications of criminal charges short of criminal inadmissibility that are more relevant for citizenship applications. The most common concern is with respect to the period of physical presence required in Canada. Your 1,095 days, so 3 years out of 5 you have to be physically present in Canada. And where implications of criminal convictions come into play is that time spent on a probation order, time spent on parole, or time spent serving a custodial sentence do not count towards your residency obligation. And similarly, with prohibitions, you're not eligible under the Citizenship Act for a grant of citizenship while serving a probation order on parole or confined to an institution. You're not eligible for a grant of citizenship if you are prohibited by virtue of misrepresentation. And you're not eligible for a grant of citizenship when you're charged with, on trial for, party to, or subject to an appeal for an indictable offense. So again, in this instance, conviction is not the hurdle, but it's the existence of a charge or a pending trial or an appeal that prevent you from being granted citizenship.
And is that in terms of the application?
No, that is the grant of citizenship. So a charge, you could apply for, you can submit a citizenship application.
You have a few months left of probation.
Yeah, and you can and could do that. The charge does not prevent you from submitting the application, but there are other implications to convictions that could arise and stand as a hurdle to the conviction or to a grant of citizenship. And that's the fact that there's a further prohibition that requires you to be prohibited from a grant of citizenship if in the 4 years preceding your application you were convicted of an indictable offense. So essentially, it puts a 4-year limit from a conviction, regardless of your probation, within the date of the application. If you have a charge, you're not eligible to apply for citizenship within 4 years of the date of the charge, or the date of the conviction, rather.
Yeah, so you wouldn't really have like 5, well, I suppose you have like 5 years of probation.
Yeah, and this creates an ineligibility where if there are multiple offenses recorded, you give yourself a limited window in which to apply. And this is particularly relevant in the cases of protected persons, or particularly minors or long-term permanent residents who came to Canada as children and were involved with the criminal justice system as young people. There's very limited windows in which you're eligible to apply for Canadian citizenship if you've had multiple convictions, because the Citizenship Act does not distinguish between youth convictions and adult convictions.
So if you have a pending charge, criminal charge, which is a high-grade offense, would you still be eligible to apply for citizenship, even though the ground is early on that?
Yes, if you have a pending charge, you are eligible to apply regardless. But the Citizenship Act treats hybrid offenses quite differently than the IRPA, the Immigration Refugee Protection Act, which I'm sure is an acronym well known in this room. Whereas the IRPA section 36(3) deems all hybrid offenses to be indictable regardless of election, the Citizenship Act doesn't specify, but the jurisprudence has established that once the Crown elects, the charge is kind of solidified. So if the Crown elects indictable, it's an indictable offense. Once Crown elects summarily, it is treated as a summary offense. It's a conviction does not preclude preclude an application or a grant of citizenship.
Excuse me, has there been any appeal decisions on the immigration and refugee thing that they're assuming that it's all by indictments? Anybody appealed that idea that the Crown has gone summarily past the charge?
Well, it has been raised in jurisprudence. I don't know if anybody's ever raised it specifically. How the court has treated it, the federal court. I'm not sure if the Supreme Court of Canada has ruled on this, but there's interplay with the Interpretation Act, which I think it's Section 34 of the Interpretation Act, but I'm not quite sure that specifies the treatment of hybrid offenses. And the Interpretation Act specifies that a hybrid offense is hybrid until election. And that's the basis for which the federal court has made findings that once the Crown elects, if they elect summarily, it is considered a summary conviction offense. Where the IRPA is different is the IRPA legislatively states that regardless of election, it's deemed indictable. And that's the basis for the different treatment. So because the statute says how a hybrid offense is to be treated, I don't see that as vulnerable to the courts on appeal. So with respect to the grant and the application, and with the treatment of criminality in terms of the citizenship application, something that's important to note is that, again, different from the IRPA, where there is a far wider availability to make requests on humanitarian and compassionate grounds, the opportunity to request waivers on compassionate grounds in the Citizenship Act is very limited. And it's fairly oddly framed, too. Convictions outside of Canada may be exempted, may be waived, or the prohibitions may be waived on compassionate grounds. Convictions in Canada are not subject to that same waiver. So there's no opportunity for you to make a compassionate argument that your client, the applicant, should not be subject to a prohibition based on a criminal conviction. The conviction is determinative of his ability to be granted citizenship. The charge, a pending charge, is determinative of his ability to have applied for citizenship. And so in this sense, we see that this topic is fairly easily dealt with. If you are criminally inadmissible, you're not eligible to apply for Canadian citizenship. But more nuanced, if you have pending charges within 4 years of your date of the application, you're not eligible to apply. If you apply and the charge is pending, Crown has not elected yet, you're not prevented from applying. You can submit your application. You could be called before a citizenship judge, and a few years ago when citizenship applications were taking 36, 48 months, you could be putting in an application with charges pending with the expectation that by the time a grant is available to you, election is going to be made, and if the election was summary, then you're in the clear, and the grant, you're eligible for the grant. Now with the citizenship processing times far less than they were 5 years ago, there's a possibility that if you apply, the Crown may not have elected by the time that a citizenship judge is prepared to make a decision, or not a citizenship officer. When you have a pending criminal charge, you are almost certainly to be invited to a hearing with a citizenship judge. And at that point, you can request a deferral of the decision pending election. And here in Halifax, I would say you would have a pretty decent chance at being granted a deferral. You can also work with the Crown. We're very responsive in my experience to have an election so that you can determine whether or not your citizenship eligibility is going to be impacted. Again, although it doesn't happen very often, I want to just quickly address the committing an offense provisions. The Citizenship Act does not specify any prohibition related to committing an offense. It talks about charges pending and convictions. But because there is potential inadmissibility for permanent residents under the IRPA, under Series 36 sub 1C, for having committed an offense outside of Canada, it is worth addressing because it could result in an inadmissibility that could preclude citizenship. Typically, the standard of proof for having committed an offense is reasonable grounds to believe an offense was committed, which is where there's objective basis for the belief based on compelling and credible information. So to go back to my example, the bigamy, if you present a marriage certificate and you cannot present a divorce certificate, there's credible and compelling evidence that you were married to two people at the same time. That's where the committing an offense arises. Permanent residents under the same section, serious criminality for committing an offense, benefit from a higher standard of proof. The offense has to be established on the balance of probabilities. So whereas the reasonable grounds to believe is something less than the balance of probabilities, for a permanent resident to be inadmissible for having committed an offense abroad, there has to be more than a 50% chance that the offense was committed. Where we would see this most often, apart from bigamy, is a foreign DUI conviction that it is reduced to something less serious than impaired driving, dangerous operation of a motor vehicle, which actually was just, with the recent amendments, was just struck from the criminal code and has been replaced with dangerous operation of a conveyance, which now attracts serious criminality regardless. So not an ideal example, but that was a, if you had been arrested for DUI in the US and knowing that you're a Canadian, the district attorney reduces the charge to reckless driving in order to secure a guilty plea, get a conviction, and have you leave the country. Having been charged with initially the more serious impaired driving offense would have been, could have led to inadmissibility on balance of probabilities for having committed that offense, even though that charge was dropped and you were convicted of a lesser offense. However, with the recent amendments to the criminal code, it's a moot point because the lesser offense in Canada would still attract serious criminality because it's a hybrid offense punished by indictment by 10 years or more.
If you never get called.
Well, that's why that's why the committing an offense provisions don't get a great workout in the jurisprudence. Because I can't speak for anybody else, but in my social circles, virtually every person I know has committed an offense at one time or another. Particularly when you look at the admissibility assessments that are now being asked in the U.S. Anybody who went to anybody I went to high school or college with, law school with, is inadmissible to the United States virtually. Because if they weren't, we probably weren't hanging out. But even if you weren't caught or charged, well, if you weren't caught, it's unlikely to ever come up. But you don't have to be caught. I've seen multiple instances where people have been found inadmissible to Canada for bigamy by virtue of marriages that it was an offense in the country in which they were, in their country of citizenship. It was an offense in the country that they lived in, and it was an offense in Canada. And they had no idea until their application was refused and they were issued a 44 report. So if you've never been caught, you're probably safe. Now you're putting yourself into danger of misrepresentation if it ever does come to light, but I wouldn't be too concerned about an offense for which you've never been caught.
Okay, if your wife tries to tell you, or you say no, please, I don't want to know.
Yeah, once he tells you, I mean, you're in a spot where you're either going to be submitting an application where you don't know, or if a client told me he had committed a serious criminal offense and didn't want to disclose it as part of his application, he wouldn't be my client anymore because I couldn't submit an application that I knew had a data misrepresentation. But yeah, judicious disclosure of past behaviors, I guess, is called for. I also want to talk a little bit about access to the IAD, and I'm sure this was, I'm certain this would have been addressed in one of the other presentations this morning. But we talk about serious criminality in terms of the Citizenship Act, which is not defined in the Citizenship Act. The reference is to the IRPA, where serious criminality is defined in 2 sections. We have 36 sub 1, which defines serious criminality, and that's kind of the meat and potatoes serious criminality. That's the one that's going to get you into trouble. Serious criminality is a maximum term of at least 10 years or a term of 6 months, more than 6 months. And that's a crucial distinction, more than 6 months, because for access to the IAD, serious criminality is defined differently. There's no reference to the maximum term, but it's at least 6 months. So the difference in definition of at least 6 months or more than 6 months is critical in terms of accessing the IAD as a permanent resident who is inadmissible for serious criminality. If you receive a sentence for which the maximum term is 10 years or more, but which you serve a term of imprisonment of 3 months, you're inadmissible, but you will have access to the IAD. If you are sentenced to a term of, if you were charged with a crime where the maximum sentence is at least 10 years, but you are sentenced to a custodial sentence of 6 months, that 6 months alone wouldn't have attracted the serious criminality or inadmissibility for serious criminality. But because it was 10 years, and because Section 64, access to the IAD, a right of appeal, defines a serious crime as one punished by 6 months, you would lose your right of appeal by virtue of the sentence. So the difference in definition of serious criminality under Section 36 and Section 64 is an important one to be aware of, even outside of the application, the context of a citizenship application.
Are there any convictions that ban you from the grant citizenship?
Well,
Like, I know we were talking earlier about, where we were talking about danger opinions, and they take a very long time, and then sometimes there are people who do have positive danger opinions who are just not removable. I mean, that would be a case for somebody who doesn't have permanent residence, I guess, but if they're to is there anything that you can just absolutely never be a citizen here?
The prohibitions serious prohibitions relate to terrorism, acts of treason, and oddly, for some of those more serious offenses, they are eligible for a waiver, whereas a conviction for an indictable offense is not eligible for a waiver.
Because they're overseas.
Well, even in Canada. But I don't know if there's a blanket prohibition, like if you're convicted of a terrorism-related offense, whether or not you would be, if it's a permanent blanket. I mean, it's never come up in my experience. My clients are all very, very well behaved.
Good for you.
If you get a life sentence, then you would always be on parole, so then you would be granted.
Yeah.
Oh, yeah, because you're not, yeah. So, you said earlier that contrary to permanent residence, the youth criminal, any offenses, convictions under the Youth Criminal Justice Act are treated the same.
Yeah.
And the probation is as well.
Yeah.
So if you had someone who's charged under that act, would you want them to make an application for citizenship and use that? To try to get out of the conviction? Like, it's pretty significant that conviction under the act precludes you from citizenship. And there are cases where, some youth clients might not lose their PR, but wouldn't have access to citizenship. And they're still, just to give an example, 15 or 16. So that seems like a pretty precious thing to hold on to. Have there ever been cases where you
wanted to kind of use the fact that that does put them through citizenship to apply for citizenship and then, ask for
There's no waiver, there's no compassionate waiver at all. The compassionate waiver under the Citizenship Act are very limited. So we've looked into that where a youth has been charged with an indictable offense which precludes them from applying. And the circumstances are compelling. There are loads of compassionate circumstances, but under the Act, there's no opportunity to make, there's no statutory opportunity to make compassionate argument. You could, I suppose, submit the application, go to a citizenship judge, and try your luck there. But my experience with citizenship judges is that it's not, it's black and white law, and they're not going to entertain anything outside of the legislation.
Does she have that, or he have the discretion to?
No, I don't think that they do. And I think, and citizenship hearings are very limited anyway. You're not present as counsel, generally. So you don't really have an opportunity to appeal to the discretion of the citizenship judge. And the citizenship judge's discretion is, with the recent changes to the Act, it's far more limited than it ever has been. At the same time, the opportunities for citizenship for young people are greater today than they were 2 years ago. Previously, there were limited opportunities for young people to apply independently, people under the age of 18 to apply independently for Canadian citizenship. The Act usually specifies a person under the age of 18 is eligible to apply for Canadian citizenship if they have a Canadian citizen parent or if they are applying at the same time as a Canadian citizen, or at the same time as their parent applying for Canadian citizenship.
Wow.
Yeah, the Act, Citizenship Act was recently, in the last, 2017, was amended to allow minor applicants to apply independently in a far greater set of circumstances than they were able to previously, which creates a lot of opportunities for young people, particularly young people who are, where this would arise most of the time is when you have young people in care who are statistically more likely to come into contact with the justice system and wouldn't have had the opportunity to make an application for Canadian citizenship without the support of a parent or guardian to kind of guide them through that. Recent changes to the Act will allow children in care to apply directly for citizenship on behalf of themselves, and even
Unless they've been convicted under the use of criminal justice.
what's that?
Unless they've been convicted under the criminal justice act.
Well, unless it's within their
Yeah.
window, yeah, that's what I mean. There's
That's
those-
surprising, I didn't know.
Yeah, there's no differential treatment for young people.
No.
No. And this isn't something that there's a lot of jurisprudence out there, because until recently there was very limited opportunities for minor applicants to apply directly on their own behalf with the support of the parent or guardian, not a parent, but with the support of the guardian. There were very limited opportunities. There are more now, but it's the young person is still subject to the same 4-year window.
When we look at time spent on probation, parole, and custody, is that for an offense even under provincial legislation or just?
It just specifies probation, parole, so it doesn't specify
So same
type
like
of offense.
criminal
Yeah.
justice.
Now, with respect to youth qualifying for citizenship, there is a waiver with respect to the physical presence in Canada on compassionate grounds.
Of the probation period?
Well, not necessarily the probation period, but today it's 1,095 days. The Citizenship Act changes more than any other piece of legislation that I'm involved with, although given my practice, I'm only involved with 2.
The pretty big ones.
It's fact. Citizenship Act isn't the reason. But with respect to the residency requirement, the 1,095 days can be waived on compassionate grounds. So if you have a child or a young person who doesn't have a conviction within 4 years, but is still on probation, you can request a waiver of the physical presence requirement on compassionate grounds. But again, like, I don't know how realistic it is to have, not be within that 4-year window with a conviction and still be on probation. I don't know if that's reasonable under the Criminal Justice Act or not, but theoretically, you could request a waiver based on a probation order. And as well with, that goes for the grant as well.
I feel bad because I'm asking all these questions.
Oh, yeah.
I'm just giving you time.
Yeah. Oh, and I also, because the short notice, I didn't prepare any aids and I don't have any handouts, so had I had longer notice, I probably wouldn't have done that either.
I was thinking that, but
But I didn't, and I'm blaming it on the short notice. I was fully expecting Lee to do this until yesterday, so thank you for bearing with me. With respect, should we just jump right into the family sponsorship?
We have 10 minutes.
Family sponsorship is even more easily disposed of than citizenship, because you are not eligible to be sponsored if you are inadmissible to Canada. So it's pretty cut and dry. If you are inadmissible for criminality, you are not eligible to be sponsored. Your application will be refused, and there's not much you can do about that. You can request a waiver on humanitarian and compassionate grounds under Section 25 of the IRPA. I have done that on several occasions, and it is difficult to get traction with the officer, particularly if there is a long history of convictions, most especially if any of the convictions involve violent crime. But even with convictions, a common conviction like a DUI, even several years old, is unlikely to be waived on humanitarian and compassionate grounds, even in some pretty compelling circumstances. But it all depends, obviously, on the family circumstances, best interests of the children, and other factors. But once there's criminal inadmissibility, you are ineligible to receive permanent residence, by definition. What's different for family sponsorship as compared to citizenship is that a foreign national, who is the person being sponsored, has a lower threshold of criminal inadmissibility than a permanent resident. Permanent resident subject to serious criminality. A foreign national is inadmissible to Canada for a conviction in Canada or out of for an offense that is indictable or would be indictable in Canada. And again, because of the deeming provisions in Section 36(3), a hybrid offense, even if it is prosecuted summarily, is deemed indictable. So, a reckless driving conviction processed as a misdemeanor in the United States, the equivalent offense in Canada is dangerous operation of a conveyance, which is a hybrid offense, indictable, inadmissibility. A person who has been convicted of an offense in Canada is eligible to apply for a record suspension, which that eligibility arises 5 years after a summary conviction offense, 10 years after indictable, I believe. If for an offense outside of Canada, they can resolve the inadmissibility by a rehabilitation application, either deemed or individual. So if the offense committed has been 5 years since the act, if it was a committed offense, you can be deemed rehabilitated 5 years after the act. If you were convicted, it's 5 years, or sorry, 10 years. 10 years after the act, you're deemed rehabilitation. You're eligible to apply for rehabilitation 5 years after the fact. And when that 5 year starts is if you committed an offense, it's 5 years from the day of the act. If you were convicted, it's 5 years from the completion of the sentence. So go back to my bigamists; they were eligible to apply for rehabilitation 5 years after their second marriage, which gave rise to the offense of bigamy. And they could apply for rehabilitation, say I didn't know, and probably be processed pretty quickly. Deemed rehabilitation, as long as the offense is punishable by 10 years or less, if it's punishable by 10 years or more, you're never eligible for deemed rehabilitation, but you can apply for rehabilitation. And for 2 or more summary conviction offenses, you're deemed rehabilitated after 5 years. Now, when you do have a criminal inadmissibility in the context of a family application, if the applicant is in Canada, you submit the application with a request for an exemption on humanitarian grounds. In the meantime, you can, if you are subject to removal proceedings, you are eligible to apply for a temporary resident permit, a TRP. If you're inadmissible in Canada and you intend to apply for a family sponsorship, you can, if you are subject to removal proceedings, you can apply for a temporary resident permit. If you are not subject to removal proceedings, in my experience, you can generally count on the good graces of CBSA not to take enforcement action. Or at least we've been fortunate enough here where if there is a sponsorship application in process and it becomes known that the applicant, the foreign national being sponsored, is inadmissible to Canada, CBSA will stand down pending adjudication of the spousal sponsorship or family sponsorship application. Where CBSA has already taken a removal action before an application is in process, you can ask them to stand down. They may stand down in a limited capacity to allow you to submit a permanent resident application. But because of their mandate to enforce removal as soon as practicable, you can't buy yourself that much time. So if you have an inadmissible applicant and CBSA is aware of it prior to the application being filed, or potentially after the application is being filed, your opportunity are limited, but you can apply for a temporary resident permit to overcome the criminal inadmissibility temporarily. Success with temporary resident permits is hit or miss. In part because the operations manuals say that because of the special rights that attach to temporary resident permit holders, the ability to receive permanent resident status as a member of the permit holders class, they want to be very judicious in their approval of TRP applications. So if you already have a sponsorship application in process, that with an estimated processing time of 12 months, you can request you're going to be looking at a humanitarian-based application in most cases.
So does it mean that temporary residents don't other comes in a way that
It does.
even if they're outside?
Yeah, it does.
We have a whole other session on
Yeah.
TRPs.
Oh, there you go.
Would you mind just briefly touching on where the principal applicant's criminality will impact the visibility of other family members?
Well, yeah, once with the principal applicant, if you have an inadmissible family member, the family members would be inadmissible anyway, but if it's the principal applicant who's the inadmissible person in a family sponsorship, well, in a spousal sponsorship, for instance, that includes dependent children, because they're accompanying dependents, if the principal applicant is inadmissible, the application is not going to get off the ground in the first place.
And there are certain situations where the principal might not be admissible, but they have a sexual crime or a crime against a child, where they then cannot sponsor.
With the sponsor, there are criminal limitations on the sponsor as well. Now, with respect to the sponsor, they're prohibited from sponsoring a family member if they've been convicted of a violent or sexual offense or an offense that has resulted in bodily harm to a family member. They are also prohibited if they've been convicted of a sexual offense generally.
And if they're incarcerated, but if they're serving a sentence, go ahead.
You can't sponsor somebody if you're serving a sentence. You're prohibited. Yeah, you can't be in jail.
But not if you're on remand if charges are pending. Can you be incarcerated and sponsor?
Could you be on a remand with charges pending? I don't know. Again, all my clients are
They're
very
still
well
behaved,
behaved.
except your high school friends.
Yeah, no, they were never caught, never
Okay.
convicted, just committed. Yeah, I don't know. I don't know if you could sponsor somebody if you were on remand. Because I mean, if you're incarcerated, you can't. But if you were released on remand, you could. Because the prohibition is for conviction. It's very limited for criminality for the sponsor. It has to be a violent or sexual offense against the person you know generally. So for both of these things, the writing is on the wall. If you're criminally inadmissible, you're not eligible to apply for citizenship. The more nuanced stuff relates to the prohibitions around criminality, not necessarily inadmissibility. Once inadmissibility attaches, you're up a river, regardless, in terms of both citizenship and family sponsorship. But there are more nuanced prohibitions that do apply.
We're going to move on to our next speaker, but thank you so much, Scott.